Thanks, Stephen. Thanks, Deal Flow team, for inviting us to be a part of this. It's been a great conference so far. We've enjoyed the other presenters. Looking forward to the afternoon. What a panel. So thank you. Thanks very much. So notwithstanding Gareth's request to spend some time on credit, Michele and I are going to focus on private equity, particularly in M&A transactions, starting from the formation of the MSO to doing add-ons to exit in a relatively short period of time. Although, notwithstanding that we're focusing on private equity transactions, I'd say in the last few years, most of the M&A transactions that we're doing in the MSO space do in fact involve credit. Most of the deals are leveraged. We're spending more and more time with our finance colleagues, and I think that's just going to continue. So, so Gareth, you're not excluded with the rest of the private equity discussions. So in the first presentation, someone asked at the end, what problem has the MSO structure solved? And the panelists answered that several problems, but perhaps the most significant is the structuring a compliant deal structure to allow private equity to invest in healthcare. And I couldn't agree more. The big issue that the MSO structure solves for is the states that prohibit corporate practice of medicine. So we have this slide that shows really two different structures. The structure on the right is your corporate practice of medicine restriction, and we're going to spend most of our time talking about that. The structure on the left, there are states throughout the country that permit non-licensed individuals to have an ownership right. So at its base, the first thing you really want to do is study that state's laws, rules, regulations to understand who a permitted owner is. Some states will allow corporate ownership, but then place restrictions on what those corporate owners can do and what the role of the physician employees are. Some states will prohibit non-licensed individual ownership, and then you still have to dig a little bit further because those states may allow someone who's licensed in another state to be an owner versus some states that require every owner be licensed in the particular state in which the practice is located. We're going to spend most of our time talking about states that prohibit corporate ownership. That's the structure where you have to have licensed physician ownership at the professional entity, be it a PC, a PLLC, an LLP, whatever the designated entity structure is within the organization. So in those structures, what we form is the management service organization, which is owned by the investors, often also owned by the physicians. That's not required, but it's a common structure to align interests and to keep building your team. And we'll talk more about that in a few slides. But in that traditional MSO structure, what Michele and I are doing when we put together the MSO or we do an add-on transaction is we're making sure that the transaction structure transfers all individuals, employees, personnel, all assets that are non-clinical. Anything that can be owned or operated by the non-licensed entity, we want to move into the MSO. The reason we want to move as much as we can from an asset perspective is we want to have a robust set of services that our management company can provide to our clinical entity. Because the way that we're getting value in the MSO is by charging a fee pursuant to an administrative services agreement. The administrative services agreement is the agreement pursuant to which our MSO provides non-clinical services, real estate, equipment, personnel, accounting, finance, management, all non-clinical services in consideration for administrative services fee. And in order to attract private equity or other investors, that fee has to be significant enough to warrant their initial investment. However, and I'll allow Michele to talk about it, we're prohibited by various laws in how we structure that fee. So earlier speakers have talked about fair market value and doing a fair market value analysis. So the greater the number of services that's provided by the MSO, the more you can justify a significant management fee.
Thank you, Mike. So one of the things I want you to come away from this morning is that in this business, the investors don't own the means of generating the revenue. You're totally reliant on somebody else or some other group of people who are billing and collecting for the services. The investors in most states just get to own in the MSO. They just get that fee that's coming from the PC. So Garrett had talked about the relationship. And the relationship is, in this situation, very, very important, because your physician owner is going to be your true partner, and you're going to be reliant on him in a way that you wouldn't be reliant if you were buying a car wash service or anything else. So when we structure these arrangements, we have to worry about complying with state law, and it's a state-by-state analysis of how much control that physician has to have. We think about the authority of the professional entity. The physician is always going to be responsible for the clinical decision-making. The physician is going to be responsible for the selection of medical equipment. In many states, the physician has to sign off on the budget. So the MSO might have a budget, but the physician, at the end of the day, has to be comfortable that that budget is going to allow him to service his patients the right way, his or her patients the right way. The physician has to control and supervise all the clinicians. So the physician, that PC might want to be able to use particular protocols and procedures. One of the reasons why you have an MSO is you want to systematize these things, but at the end of the day, it's important that the physician has that control. The fee is going to be, in many states, required to be a fixed fee because of fee splitting concerns. Sometimes you can have a percentage-based fee. And we'll talk a little bit later about how you, quote, tie up the physicians through restrictive covenants. The MSO in most states cannot restrict a physician from practicing medicine. So part of what we try to do together is make sure that all the documents together will prohibit that physician from setting up shop down the block, the next county, in a competitive business, competitive area. The other thing that I want you to come away from today is to understand the real unique regulatory due diligence concerns. So what happens when I get called in, the private equity firm has already started their quality of earnings, and that's a great number. But what you need to be concerned about, because you're billing and collecting from payers, including Medicare, is that when the doctor is billing and collecting, that they're doing it in accordance with law. So that quality of earnings has to be done simultaneously with a billing audit. I could tell you over the past 7 years, a billing audit was something that was done probably less seriously, and now they're done at the front end very early on when the quality of earnings is being done, so that you could test what's going on in the practice. Other things that we worry about from a regulatory point of view are, and there's a whole list of them, but we worry about the things that our other colleagues were talking about, Michael, all of the referral patterns. We want to make sure that there's no violation of the anti-kickback law. And another important piece are the HIPAA requirements. What we're seeing now is that lenders to these deals are very focused on both the billing and the HIPAA issues and won't even proceed unless there's been a HIPAA risk assessment. So these are things, and again, probably seven years ago, the healthcare piece came in at the end of the deal, and you're seeing it more coming in at the beginning of the deal to make sure that all the I's are dotted and the T's are crossed. We can go to the next slide.
Okay.
Do you want to
So-
talk about the responding to the due diligence list risks?
Sure. We'll go briefly through this slide as I'm watching the clock here as well. Michele mentioned all the various types of legal due diligence that we do for the M&A folks in the room. You have your traditional negotiation around indemnity. So healthcare has a whole set of reps and warranties that you wouldn't see in a non-healthcare transaction, and we spend a great deal of time negotiating those particular representations and warranties, and then we negotiate whether or not those reps and warranties should be treated like a fundamental representation, which typically is accepted from certain limitations, or if it's treated like a business warranty and subject to caps and baskets and survival periods. So there's a sort of second layer of negotiation that we deal with. Although in some of the more significant transactions and in the more recent history, we're seeing more and more rep and warranty insurance, which you could have a whole day on in and of itself, but that relieves some of the pressure that we have on those negotiations.
It does relieve some of that pressure, but because many sellers are coming into the deal saying that we want a rep and warranty deal, we don't want to have any liability on the back end, so the buyer is accepting that. You worry about how much insurance you get and whether there are any realistic things that could come above that. So some things that might not have been cleaned up, maybe some stark self-disclosures or fraud and abuse issues, might be more sensitive to getting that cleaned up before the closing so that there's no extended liability.
So perhaps the most significant due diligence project in a healthcare deal, and Michele already mentioned it, is the private equity or other investor and the physician group or other provider group getting to know each other and determining whether or not they'll in fact be good partners and be a good match. Because as we've mentioned, in the states that prohibit the corporate practice of medicine, there is a lot of control and rights that the physicians have by law that we cannot contract out of. We can try and mitigate that risk, we can put certain protections in there, but it's imperative that the investors have confidence and have a good relationship with the physicians, especially the founder physicians when structuring the initial investment and formation of the MSO. And one way that you can do this is to align interests as much as possible. And this slide, use of rollover equity, I think most often people think of rollover equity as another form of consideration. It's less cash that the investor needs to put into the deal. It gives the seller, the physicians in this case, skin in the game and the potential to exit a second time at a higher multiple or with more significant EBITDA. So there's all the economic discussions that you'd have. But from my perspective, and Michele and I have talked about this over the years, the greatest utility of the rollover equity is that, did I just kill this?
Yeah.
No, of the rollover equity is that it aligns your physician group with your private equity sponsor, and that is the greatest amount of protection you can have when you worry about a physician group going rogue, which is something that is very difficult to deal with, and we've had the pleasure of dealing with that in a few cases.
So there are a number of reasons why the physician goes rogue. One of them is that his or her rollover equity is not really worth anything. So the MSO then becomes hostage to the physician owner in the PC. And we have tremendous number of ways, legal ways, and I'm putting that in quotes, legal ways that they are legal and they are enforceable and they are valid ways to tie up the physician, but it becomes very difficult to operate a business when you're relying on that physician and that physician is not cooperating. So all of these things that we have, tools at our disposal, like stock transfer restriction agreements or succession agreements where the manager can change the physician or at the manager's desire, or requirements in the management agreement that the bank accounts be swept daily into an MSO account. All those things are very nice when everybody's getting along. When people are not getting along, that becomes a very challenging situation. We need to put all those protections in place, but it goes back to what we said at the very beginning. You need to make sure you're comfortable with this partner because you're very reliant on this partner.
So we talked about rollover equity, and in the traditional sense, the rollover is into the same entity in which the private equity or other investor has contributed capital. And that is a very common approach, as you would expect. That typically means that the physician partners are participating in the entire enterprise and that they're incentivized to grow the business, whether it's regionally or nationally, but they have the same type of equity as the investors. There are other ways to create equity participation by the physician group. Michele and I have worked on transactions where the equity is in the clinical entity, and the way that the fee is structured and the waterfall that's within the administrative services agreement are such that the physician continues to participate as an equity holder in the professional entity. And I'm differentiating that from a different structure where the overwhelming majority, if not all, of the economics flow up to the MSO through the administrative services agreement. So there's a way to participate in equity at the clinical level, and that's very focused, right? Grow the office or offices that PC operates in. We've seen this concept of a sub-management company. So you put a new entity as a subsidiary of your management service organization, and you offer equity in that subsidiary, and that subsidiary would manage a subset of what the management service organization manages. Maybe it's a state, maybe it's a few counties, maybe it's a handful of states, but then you can create sort of like regional hubs and regional P&Ls, and that is a way to incentivize a physician to grow his or her geographic area. Once you do offer the equity, whether it's at the MSO, at a sub-MSO, or clinically, then you need to consider transfers. Whether that's what happens if they leave the business, they're no longer providing service within the business, whether it's a way to clean up the pre-exit, right? So you can take out all of your physician owners. So we've often negotiated puts and calls and mandatory redemptions as part of the various equity participations, and that does create its own regulatory issues. So you just have to be mindful, and the prior presenters have mentioned some of the issues that come along with that as well.
So the next slide is about operational challenges, and when we put this slide in, what I was thinking of were the add-on acquisitions. So part of what you're doing when you get private equity investment is you're getting capital so that you could grow the business, and then you want to buy additional practices. Many of these practices will be smaller practices, they'll be founder practices, but you'll still need to do the due diligence. We expect that most of them, or we like them to be asset purchases if you can, but you have to worry about, for instance, if you go into a new state, you might need the payer agreements from the target, because that's the first time you're in that state. So it's more important to do a stock deal. But you go through the same sort of regulatory due diligence. As a regulatory lawyer, what I see is that once you get the private equity investment, then you're off to the races, and sometimes you don't pay attention to the integration. So you don't know, you're trying to build a brand, but you're trying to get growth, and you're not integrating the practices the way that they should be, so that they're best practices among the practices, and that they're the same billing and collection procedures and all, and that's something important to keep in mind.
I think we actually just ran out of time, so let's skip the last slide.
But I don't want to skip the last one.
Okay.
Because it's interesting. I just one theme that has run through, and it started with you,
I'm going to blame.
Henry,
I'm going to tell Stephen.
Go ahead. Well, it started with you because you said not to say a dirty word about making money. Healthcare still is a space where there's a little schizophrenia in this country, that you are not supposed to be, it's supposed to be a noble thing, and maybe you shouldn't be making so much money. So when the government looks at these businesses, they'll look to see, and they'll notice that you're making money, and that in and of itself could be a bad thing. So when you see emails where the private equity firm is suggesting maybe that you should do X, Y, or Z to get the patients through the door, you have to be very careful. And this was a slide about enforcement trends, which the other attorneys talked a lot about. But this, I think it's really important to think about the sensitivities of this industry in government, in the government crosshairs. We do want to make money, and you do want to do it in the right way.
Any questions?
Good question. You had mentioned that it's desirable that the fees charged by the MSO to the clinical entity should be fixed to whatever extent you can to avoid the corporate practice of medicine.
Well, in some states, they have to be fixed.
Okay, so
There's a fixed fee.
what about a situation where what the MSO is providing to the clinical entity is IP, intellectual property? CityMD, the trademark and the logo, is owned by the MSO. It grants to the clinical entities the right to use that trademark, like the franchise owner grants the franchisee the right to use McDonald's. And typically, those rights are conveyed through a royalty type of an arrangement where a percentage of revenue is the fee. Can't do that?
Can't do that. You need to have in a state like New York, in many states, it has to be a fixed fee. The fee can be adjusted, or frequently the costs are run through, so that in the event that the business is growing, the fee can go up because the costs have to be reimbursed, and some profit on the cost can be there. But you can't do that. You can't do what, in terms of sometimes in retail spaces, the rent is based on a percentage. You can't do that either.
So the franchise is a good example, right? Because those fees are typically percentage-based. In my experience with medical franchises, you have two layers of management services, right? The franchisor and the franchisee, both non-clinical entities. You can have percentage-based fees between non-clinical entities, but the relationship in the states that Michele is referencing between the clinical entity and the franchise must be fixed. They can't do that percentage franchise type fee.
Just two quick questions. One, to follow up. I know that the fee can't be a percentage, but could you use that model to think about what the fee should be, like as an input to a fixed fee? Say, oh, this is what those fees usually are in those types of models. We can't use a percentage base, but we're going to use that as an input to figure out what the fixed fee should be, and here's the fixed fee.
So one thing that we didn't mention, which we should have mentioned, some states do allow percentage fees. New Jersey, for instance, allows percentage fees. But one of the things you will need to do is get a fair market valuation of the fee. And what happens is that the valuator will look at fees of similarly situated companies, and they will determine whether your fee is within fair market value. So that is one thought process, right? Because your percentage is, you're thinking about what other companies charge, and that's within fair market value. But we recommend that you get a fair market value fee assessment when you go through with the acquisition.
Another protection for that issue is, in addition to the fixed fee, you can typically charge cost plus. So the cost plus protects the MSO from sort of significantly undershooting what the fee should be, because if you're getting reimbursed your costs plus some margin, and then you have the administrative fee on top of that, it reduces your risk there.
So you're allowed to have both of those in place?
Yes.
Okay. Well, because the only reason why I ask is typically, you're capped at a certain percentage. If you do cost plus, you can't really go too high. It's got to be 20, 25%. Start getting over that, it's crazy. So if you have cost plus 25%, and then you have an administrative flat fee on top of that, added together, it's a greater percentage.
Sometimes you can do that, and
Okay.
but again, it goes back to getting the valuation to
Fair market value.
Yeah.
Yep.
Yes, so the valuation firm will value both components if you're going to have both components together. So you're right? If the margin's too high, it might bring down the administrative fee, like they're levers.
Got it. And one last question, and sorry, it's taking a little bit second, but on the corporate, the legal structure of the entities, I know that one slide, you've got kind of a restricted stock agreement, and I was curious if you could spend a couple minutes or a couple seconds talking about specifically New York State, because my understanding is that the restricted stock agreement in a traditional sense limits dividends and things like that, doesn't fly in New York State, and so you'd have to build some of those into the MSA rather than have a standalone agreement, but I was just curious if you could chat about that.
So this is all, it is, I would say, 50% of the lawyers in New York State will say you cannot have a stock transfer restriction agreement. And then 50% of the lawyers will say you can, and you might not be able to, it might not be enforceable, so what's the problem? We don't like using them because we think it's a bad fact. So in New York, what we do sometimes is we have an option agreement between physician and physician that the manager does not control, so it's a friendly type relationship. We do have restrictions in the management services agreement, but those are very negotiated depending upon how the lawyer on the other side views the corporate practice, number one, and sometimes naturally they'll use the corporate practice doctrine to say, as a sword, to say that you can't do that, but it's really a business reason why they don't want to do it. And at the end of the day, for me anyway, it's a view of the whole deal. It's not one fact. It's at the end of the day, is the doctor really the one who is running the practice? Who, if a regulator shows up, the nurses, the staff knows that they work for that physician. It's a whole, like I say, it's a whole gestalt. It's not one thing in those documents.
Regarding the corporate practice of medicine, where do you see the threat coming from? I thought in most states there was no private cause of action under the corporate practice of medicine. Would be the AG's office that's going to weigh in?
So we had a case a number of years ago in New York called the Aspen Dental case, which many of you might know about. That started from the consumer complaints, and that was the AG, and they required a change to the dental practices, and they were pretty egregious consumer complaints. It wasn't really the corporate practice, but they built all of that in. And in that case, the AG required Aspen to pay $400,000. So we as practitioners have said, if that's the worst that happens, that's not so terrible. That was not a terrible thing. But there's a whole other line of cases that are percolating in New Jersey and some in New York where insurers are saying that they're not required to pay claims because of the corporate practice of medicine. In those cases, there are some really bad facts. Again, the doctor is really a puppet. The entity is really being orchestrated by the MSO. They're real docs in the box, but that is a real, it's a real threat. Now, on the other side, if you take away all this private equity investment, who's going to invest in healthcare in a state like New York? This is a highly politically charged state. The hospitals have not wanted private equity, but and we lag behind. So you're seeing deals in New York. I think a lot of private equity firms, lenders are still afraid of New York.
As a follow-up, Senator Pallone and whoever from Oregon recently requested, related to the out-of-network surprise billing, information from KK&R, Blackstone Group, Wells Carson Anderson Stowe, and I think somebody else, regarding their finances.
Yeah.
He wants everything
Yep.
for his committee. Do you see the states taking that information and using that to attack the role of private equity in medicine?
I think it's, the last speakers are, going to talk about the bad publicity. I think it's a risk, but then I go back to where is the money for the healthcare system going to come from? So I think that it's important to do the right thing, to be good citizens, to be able to show that your business is not causing unnecessary costs into the system and is even helping. But all those things are real.
I think you're good.
We're done?
Yes. Thank you.